Let's talk about and/or nominee. It's something that hasn't really been accepted in Alberta legally for over a decade, yet we're still seeing it on contracts at times. So let's break it down and talk about why. So parties to the contract, if you remember from your real estate course, the party to the contract is one of the 5 core contract elements. So both parties have to know who the other party is. The same reason you can't have an unnamed person. So what and/or nominee does is effectively that. Now we've contacted RECA, area, and several lawyers for opinions on this, and it's still being used out there fairly often in the investment side of things or with investor clients. But the reality is, if it's court tested, how is it interpreted? So the current kind of precedent with the Alberta courts is, which is it? They don't know how to interpret and/or nominee. So is it and? If it's and, then who's the other party? You have to name them. They have to sign the contract. They have to fill out all the other disclosure paperwork, FinTrack paperwork, etc. And if it's or, like this person or this person's going to buy it, then who is that other person? And how are you contracting them to an agreement that they're not signing and they're not part of? If I always use the example, if that would work, I could just nominate you to buy a property for me and say, yep, it's me or this other person, and they're going to buy it and buy this property on my behalf. So obviously you wouldn't want to be that person if I was buying some multi-million-dollar property that I was obligating you to. So that's why all parties have to sign the agreement, logically, right? So how do you handle situations, which is the most common one, where you have a buyer that maybe is going to close in a corporate name, or maybe has another party that's going to go on the deal with them. Maybe it's a spouse, maybe it's a business partner, maybe it's a parent or something like that, and you don't want the seller to be able to deny that. So this is where terms come in. So the most effective way to deal with these situations is by writing a term that is something along the lines of, the seller hereby agrees to allow the buyer to have a change of name to a related party prior to closing date. Something in that realm. There's different scenarios that apply, so to kind of each scenario there, whether it's a business partner or a corporate name, you can adjust the wording accordingly. So feel free to reach out if you have specific situations. We'll put some sort of suggested wording down below here in the comments as well, but you should always have them talk to their lawyer that's going to close the deal. Because if they're going to deal with this at closing date and bring in some other party to the contract, the lawyer needs to be in the loop on that fact. They need to also make sure that it doesn't impact their financing and it doesn't impact their insurance or any other elements to the deal that are required to close the deal, right? And one last element that I'll add on this topic is deposits. So we often get this situation where someone's transferring the deal maybe to somebody else, and they're replacing the deposit and saying we want to issue the deposit back to buyer number 1 now that buyer number 2 is taking over the deal. Can't do that. When a deposit is given, that at that point it's considered a gift to that person. So whoever's listed on the purchase contract as the buyer is, if that contract number that deposit is attached to collapses, then we return the deposit to the buyer named on the contract. So be aware of that. It's up at the point that they've, maybe a parent or a business partner has given the deposit check. At that point, they're giving that money to the buyer, and they need to have their own relationship or agreement in place if they're requesting that money back if the deal falls apart or they're replacing it or something like that. So just be aware, terms of trust, the deposit matches the contract and the parties named on that contract. So as always, if there's any other changes you're making, then you do it via an amendment, right? And so even if you are changing that name after the deal's firmed up, or at any stage of the transaction after you've got a pending deal, you do an amendment and change the buyer's name, and then in that case you need the original buyer that was on the contract to initial and sign that amendment, as well as this new named party. And we generally recommend that you get that new buyer, if it's like a parent or business partner type thing on an investment property buying it, that the new buyer also go back and like initial the full original contract, or you attach the full contract if you're doing it in an e-signature platform. Here's the amendment, and then here's the full contract attached. So don't just do an amendment as a standalone document that says you hereby agree to, like, you know, add your name to this contract, and everybody signs that. It could be court contested that they didn't understand what they were signing, and so you want to attach the full agreement that they're now binding themselves to. So feel free to add any other comments, questions below in the comments, or reach out, and we're always happy to clarify these kind of situations to help deals run smoothly and everybody to have a nice, happy transaction at the end of the day. Talk soon.